The most interesting part for the world to listen is paragraph 52. The judge talks of a galloping litigant. A galloping litigant is a litigant moving scenes of the same forensic battle from one jurisdiction to another, engulfing nearly all institutions and means of dispute resolution, either simultaneously or successfully, with little or no merit, and putting a pinch of criminality on or otherwise civil disputes must be stopped. And if a subordinate court entertains him, the High Court must check it. Experience has shown some litigants who will dress up their disputes in so many garments and present them to every authority available within our national borders, and even personalities with no legal powers here to assist in the resolution of the same dispute. They vex their opponents and everyone else. They may be reminded to verify, intimidate, and block. The authorities are there. My team of associates should deal with it. You know, what is before you is a serious abuse of the judicial process. It is the ODPP in Mavoko who approved the miscellaneous application. It is the DCI who came to court and took the dog against bad advocate. They are the same officers paid by us who now want to vex, to harass that respondent. Thank God Article 50 came in. The police could have detained her for 10 years. But we said no under the new constitution. They must be brought to court within 24 hours. We know very well, Your Honor, it is not these friends of mine who are police officers here. There are powers above them. That have sworn life and death, this girl, her mother, and her father, and her mother, and her brother will never see freedom. The first miscellaneous application was before your brother, Honorable Nsarifu. We argued it. The second one was before Honorable Kwamboka. We argued. Today we are before you. After we dispense with this one, Monday they will be in Kibera or elsewhere. You know, this is what we are seeking, that these miscellaneous cannot be admitted. And we will crave for that ruling. In the judiciary account, 1 million shillings of that advocate is there. She's released on the investigation about the death of Dr. Victoria. The police arrest, they ignore the cash bill, they bring that to you. You know, before the radical surgery of the judiciary, it was normal during the Chunga time. It was normal for people to be dragged to court. They plead not guilty, the courts enter guilty, and they are sentenced. When the radical surgery came, those issues were brought up. You know, remember that time, interviews by JSC were not existing. Because once somebody has been appointed a judicial officer, that's fine. Today, we are on performance-based approaches and merit-based interviews. These state want your file to be put a black mark. Had this thing been brought to you and you looked at that, you could have raised your pen and said, I put it down. So that they either take her to DCI headquarters and detain her there, or detain her away from the judicial. Your Honor, in summary, my final remarks is that this PO must succeed because the law provides for protection. This is a word of the court. This is an office of the court. This is a vulnerable suspect before you. If they have evidence to charge her for murder, nobody can stop the DPP from charging her. But they cannot be producing every day miscellaneous application over the same issue. Let me allow the voice of Our Lady to come to soften the proceedings.
Good afternoon, Your Honor, once more.
Good afternoon.